than that, after voluntary retirement, he empowered 5 lakhs tribal students in terms of teaching English, teaching about Baba Sahib, and teaching about survival, all the things. Again, he read all the volumes of Baba Sahib Ambedkar and he is expert on constitution. Is also an excellent scholar in scholar of Buddhism. Is a dedicated social activist and is a entire life dedicated to the downtrodden people, marginalized section. Now also, I am very happy to hear his speech on a constitution. Thank you so much, sir.
Thank you, Siddhuji Garu, and for introducing me in a very loud words, which I may not deserve. Anyway, I really thank the Center for Dalit Studies and Sri Mallepalli Lakshmaya Garu for asking me to speak on this occasion on this topic, Dalits and the fundamental rights in Indian Constitution. As introduced by our friend Mr. Dr. N. Siddhoji Rao, I am not a great scholar of either Constitution or Buddhism. I read regularly something about these things so that I can enrich my knowledge from time to time as a student of Ambedkar. This is the only qualification I have. Otherwise, I am not a trained lawyer or a trained Buddhist. I am just a simple servant. I was a simple civil servant for quite few years ago, and I have taken voluntary retirement at the age of 51. Of course, to serve the community. It was a conscious decision. At the time when I joined the civil services, I wanted to serve the state only for 50 years of age. And after 50 years, I wanted to come out and share my experience, exposure, and knowledge and understanding about the administration and the society to the younger generations as much as possible. That is why I took voluntary retirement at the age of 51, and I'm doing something or the other after taking voluntary retirement. Today, I am really honored to speak on a topic which is very huge. In fact, Dalits and the fundamental rights in the Constitution of India is a very big subject. Anyway, to go into the subject, fundamental rights has two words in that. One is fundamental and the other is rights. What is a right? A right is a necessary condition for a decent life of an individual, for an individual to live decently with respect. A necessary condition, essential condition should be there surrounding him. That is called a right, as it is a very academic definition of a right. So the fundamental rights means the fundamental conditions that should prevail in a society for the well-being of an individual. Then what is the difference between the fundamental rights and the constitutional rights, fundamental rights and the civil rights, fundamental rights and the human rights? These are various connotations of rights, and it depends on the context in which we are speaking. For example, the fundamental rights are those rights which are defined or described as fundamental in a particular statute or a law. In that sense, whatever is written under the heading called fundamental rights are fundamental, and all other rights, many other rights will be there. There will be civil rights, some rights emanating out of an act of parliament or act of a state. Every act gives some rights to the citizens, and the citizen will have the facility of claiming that condition for existing to exist for him in the environment, in the society. He expects the society to respect the rights that are given to him in a law, either a civil law or a criminal law or whatever it is. They are the civil rights. See, the fundamental rights are those which are defined under the Constitution of India, Part 3 of the Constitution, defines the fundamental rights of Indian citizens. And some of the rights are available to non-citizens also. For example, right to equality is a right for every person who is residing in India. It is not only limited to the citizens of India. Why they are called fundamental, what is the difference between fundamental rights and other rights is the primary thing to be understood by all of us. A fundamental right is also a common right, but it becomes fundamental for the simple reason if that particular right is violated by any person or a state, the individual who is aggrieved of that violation can go to a high court or a supreme court directly without going in the normal procedure of claiming the rights. All other rights other than fundamental rights have to be claimed in the hierarchy of judicial organization. For example, the lowest court, municipal court, one has to go. After the municipal court, somebody will go to the district court. After district court, the high court. And after high court, it is the Supreme Court. This is the hierarchy in which one has to go for any civil right, any statutory right, or any other right other than fundamental rights. If it is the case of a fundamental right, a violation of a fundamental right, an individual can directly go to the Supreme Court under Article 32 of the Constitution or to a High Court under Article 226 of the Constitution. And there will be writs. So this is the very difference. Why some rights are defined as fundamental and for whose protection a direct channel is given to the High Court and Supreme Court is the logic behind defining certain rights as fundamental. These rights are so essential, the violation of which cannot be, the justice against violation of which cannot be prolonged for years and years and years together. Therefore, there should be immediate relief for the individual. To the earliest possible, justice should be done to the individual who goes to the Supreme Court or the High Court for protection of his fundamental right. That is the biggest difference. Other rights will be there. For example, right to equality is Article 14 and right against discrimination is Article 15. Right to equal opportunity in matters of public employment is Article 16. And prohibition of untouchability, abolition of untouchability is given under Article 17. And abolition of titles is given under Article 18 of the Constitution. This is called equality code under the Constitution. Equality, right to equality is spread into all these 5 articles, Article 14, Article 15, Article 16, 17 and 18. All these 5 articles together become the equality code under the Constitution. Violation of any of these articles will be a violation of equality, right to equality. Therefore, for any violation of these 5 articles, a person can go to the High Court or Supreme Court for claiming that right. This is the difference between fundamental rights and other rights. Then what is the real protection for these fundamental rights? The protection for these fundamental rights comes through Article 13 of the Constitution. Article 13 of the Constitution says, any law or any whichever custom, tradition, or the usage, law, bylaw, or any ordinance or notification, whatever is defined as law, if it is made before the commencement of the Constitution of India in 1915, January 26, 1950, any law that is made before the commencement of this Constitution, and if that law is going against the fundamental rights which are given under Part 3 of the Constitution, from Article 12 to Article 35, from Article 12 to Article 35 are defined as the fundamental rights under the Constitution of India. And any law made before the commencement of the Constitution, if that law is contradicting any of these fundamental rights under the Constitution, will be void. That is Article 13.1. Article 13.2 says, any law made after the commencement of this Constitution, if it is contravening any of the fundamental rights defined under Part 3 of the Constitution, will be void to the extent of that Constitution. There's a contradiction. If a law is made contradicting any of the fundamental rights from Article 12 to Article 35, if it is contravening these articles which are defined under the fundamental rights, to that extent, any law made by Parliament or the state will be void. That is the protection given by the Constitution itself under the fundamental rights to the entire, to cover all the other fundamental rights. That means Article 13 of the Constitution gives protection to the fundamental rights. Article 12 of the Constitution defines what is a state and what are the agencies that come under state. This is Article 12 is the definition of state. Article 13 defines what is law and defines what are the laws in force, and also gives protection to the laws that are made after the commencement of the Constitution, and also makes void all those laws which are made before the Constitution but which are contradicting the fundamental rights given under the Constitution. This is the difference. So what is this Dalits? Who are the Dalits we are talking about, and what are their fundamental rights under the Constitution? This Dalit community, as we know, this is a general nomenclature for the officially declared scheduled castes under the Constitution. The scheduled castes are defined under the Constitution, and Article 366 Clause 24 of the Constitution defines scheduled castes. Article 366 deals with all the definitions which are special to the Constitution of India. For the Constitution of India, whatever definitions are given under Article 366, various terms are defined, and the definitions given under Article 366 should be taken as it is for the interpretation of the Constitution. So now, the scheduled castes, who are otherwise known as Dalits in the common nomenclature, are defined under Article 366, Clause 24. And it is a deeming clause. I am going a little deep into the legal aspects of this definition. It is a deeming clause for the simple reason the definition says the castes which are listed under Article 341 of the Constitution shall be deemed to be scheduled castes for the purposes of this Constitution. This is the broad definition. That is a deeming clause for the simple reason, if there are 1200 odd castes which are defined as scheduled castes across the country, under Article 341 of the Constitution, have to be deemed to be scheduled castes. Otherwise, this is a global definition for the scheduled caste. Without this global definition, implementing laws involving scheduled castes, involving untouchability, involving welfare measures for the scheduled caste, involving development policies for the scheduled caste, involving special protections that are given to the scheduled caste under the Constitution will become very, very difficult. Therefore, a deeming clause is a clause or a definition which asks the citizens, which asks the lawyers, which asks the judiciary and judges to use the definition as it is given under the Constitution without any hesitation, without any additional information necessary for redefining it. This is a very, very important thing. Deeming definitions under the Constitution or under any other law are very, very important. These deeming clauses are also known as legal fictions. are also known as the artificial constructions. Some definitions are artificially constructed, some definitions are legally defined. They are called deeming clauses. They should be taken as it is while interpreting the laws pertaining to those definitions. This is one condition which the recent Supreme Court judgment on August 1st, 2024, the Supreme Court has delivered a judgment in a case called Devendra Singh versus State of Punjab. In that Devendra Singh versus State of Punjab case, Supreme Court has diluted the very deeming provision of the scheduled caste. The Supreme Court judgment said that there is no deeming clause in the deeming clause itself. That means the Supreme Court is not accepting the definition given to the scheduled caste under Article 366, Clause 24. This is the biggest twist that had come in the interpretation of the laws regarding the scheduled caste as far as the Supreme Court and the fundamental rights are concerned. See, I am going a little deep into the subject. I have gone into a little deep into the subject because this is the most current aspect as far as the definition of scheduled caste is concerned. The moment the Supreme Court challenged the very definition of scheduled caste under Article 366, Clause 24, it is diluting the definition or the very meaning of untouchability that is very much essential and very much part of the fundamental rights of the Constitution. The practice of untouchability, which is abolished under Article 17 and which has been declared as an offense under Article 17 of the Constitution, the practice of untouchability in any form is abolished, and the practice will attract punishment under the law. That law is the Scheduled Castes and Scheduled Tribes Abolition of Untouchability Act, or Atrocities, Prevention of Atrocities Act 1989. So this is cutting the very foundation. This is breaking or diluting very foundation of the definition of scheduled caste and the very existence of Supreme Court of India in the latest judgment, which I mentioned earlier, that is the Devendra Singh versus State of Punjab judgment. Supreme Court is denying the very existence of this untouchability in the society today, or it has diluted the practice of untouchability in its legal definition. That is the definition of the scheduled caste. These are the very recent trends which are very endangering trends, very poisonous, vicious aspects that are taking place as far as interpretation of this Dalits and their fundamental rights. I will go into those details after a while. These fundamental rights are, again, we have equal right to equality rights up from Article 14 to Article 18. We have right to freedom, we have right to life, and we have right against exploitation. We have right to religious freedom, and we have right to cultural freedom. We have right to constitutional remedies under Article 32 and other general rights up to Article 35 of the Constitution. These are the broad fundamental rights in the Constitution. What I want to discuss now is, I don't want to go into the details of all these fundamental rights. I want to discuss 2-3 aspects which are really agitating the very foundation of the legal protections or the constitutional protections that the scheduled castes have under the Constitution. If you go into the history of these fundamental rights, some individuals these days, some ill-informed individuals are coming out with an argument who wrote the Constitution, and coming out with an argument who wrote the fundamental rights, who gave the fundamental rights to Indian citizens and to the untouchables. These are the questions that are being debated, discussed, and the history is being distorted by certain what do you say, anti-social elements from our point of view. If you go into the debates or the discussions or the submissions of Baba Sahib Ambedkar to the roundtable conference, when the entire roundtable conference, the very first condition that Baba Sahib Ambedkar put for as a necessary condition for any Indian constitution to be drafted in for the future of India is the fundamental rights of equal citizenship. Fundamental right and equal citizenship is the first condition. First condition is enjoyment of equal rights as a citizens, free enjoyment of equal rights as citizens. Equal citizenship is the first fundamental right. I want all of you to understand one thing here. Citizenship is a bundle of rights. If you are a citizen, you will have the rights. If you are not a citizen, you will not have any rights. In a country, we are living in a territory of a country. You are just a resident of a country. You are not a citizen of a country. Only when you are given certain rights under the constitution, you will become a citizen. Otherwise, you are called a subject in a country. Subjects are people under a monarchy or under a dictatorship. But under a constitution, under a republic or under a democracy, you are a citizen. You are defined as a citizen, and citizenship is a bundle of rights. It is a bundle of various rights like right to education, right to life, right to live, right to equality, right to freedom, right to civic communities, right to all these rights are a bundle of rights and for a citizen. But there are two most important rights that Baba Sahib Ambedkar points out, that right to vote and right to represent. These are the two very, very essential fundamental rights in a constitution. Without these two fundamental rights, the other fundamental rights or other rights for citizens will have limited application, will have limited meaning. This is the philosophy of Baba Sahib Ambedkar. Now, this philosophy of Ambedkar in the roundtable conference, the entire discussion is surrounding the untouchability and freedom from untouchability, protection from untouchability, and removal of untouchability or the abolition of untouchability. This is the most essential part that Baba Sahib Ambedkar was involved in during the roundtable conferences, when he is putting forth the safeguards that are necessary in the future constitution for India for the untouchables. He has detailed some 8 safeguards for the scheduled caste. The first safeguard is equal citizenship. The second safeguard is freedom, free enjoyment of equal rights. You will have rights declared under the constitution, but will you be able to enjoy those rights in the given social, economic, and political circumstances becomes the next biggest question in any society. Baba Sahib Ambedkar's vision went in such a way that unless the rights that are given in the constitution are again protected by another right, they will not be able to enjoy. The scheduled castes or untouchables will not be able to enjoy those rights which are given to him. Therefore, he came out with the second condition called free enjoyment of equal rights. It's a very subtle difference. Under free enjoyment of equal rights, Baba Sahib Ambedkar comes out with 4 essential conditions that should prevail in the context of scheduled castes for them to enjoy the equality rights under all any equal rights. What are those 4 conditions? I will read out. They define scheduled castes are given equal rights. For example, they go to a well or a tap or a tank to draw water from it. It is equal. They have been given that right under equality. When the scheduled castes want to enjoy that right to draw water from that well or a tank or a tap, common tap, the society will come in their way. So, and the entire society, which is in majority in a village, or the untouchables are in a minority, this majority in the village can boycott these untouchables from taking that water, and they will physically obstruct. Then what should be the law? This is the thought process that is going into Ambedkar's idea, and he came out with offense of boycott. If the scheduled castes are boycotted from enjoying any of these rights, or purchasing anything, going on walking along a road, drawing water from a common tank, or taking a bus or whatever it is, these are all common rights. When scheduled castes are going to number one, under free enjoyment of equal rights. Then, if the definition is made, then Baba Sahib tells punishment for boycott. If any scheduled caste person is boycotted, the society which is boycotting the scheduled caste should be punished. That is the second condition, punishment for boycott. Baba Sahib did not stop there. He goes further and puts a third condition for the prevention of untouchability. The third condition was punishment for instigating or promoting boycott. Some persons will be there, they will not physically obstruct, but they will be behind the screens, they will be instigating other people to boycott, and they will promote boycotting the scheduled caste, and that is also made an offense under the Prevention of Atrocities Act. Now, this was visualized by Baba Sahib Ambedkar in 1932 when he was talking about the special safeguards under the Constitution. And the fourth level that Baba Sahib Ambedkar is talking about is punishment for threatening a boycott. If the scheduled caste member or a family of scheduled caste or a hamlet of scheduled caste is threatened with the instrument called boycott, and they were made to live under certain abnormal conditions, or made to do certain things which are not permitted under law, that is also made into a punishment under the law. These are the four special conditions for scheduled caste for enjoying their equal freedom, equal rights. Then protection against discrimination. You know that the discrimination against the scheduled caste is emanating from the caste-based discrimination. And this definition, this particular discrimination clause is built into, particularly discrimination against scheduled caste is built into Article 15(2) of the Constitution. The language of Article 15(2) of the Constitution is directly related to the scheduled caste. But unfortunately, when the Equality Code is interpreted by the Supreme Court and High Courts, so far after the Constitution, in the last 75 years, Supreme Court and the High Courts are interpreting the Equality Code as Article 14, Article 15(4), Article 16(4) of the Constitution, but not any other article is being interpreted as Equality Code as far as this scheduled castes are concerned. Article 15(2), after these Article 14, Article 15(4), and after Article 16(4), people directly jump to Article 17 in some cases as the Equality Code. But Equality Code under the Constitution is a very, very critical concept, very, very essential concept, that the 5 articles which are mentioned under Equality Code in the Constitution cannot be separated from one from the other. That should be the stand of any Dalit lawyer, stand of any Dalit judge, or stand of any Dalit who wants to live enjoying the rights given under this Constitution. This is my submission to this August gathering now. Because this discrimination under Article 15(2) is directly relevant to the scheduled caste only. Then Baba Saheb comes to adequate representation in the legislatures. This adequate representation has again become a big legal issue these days with the latest judgment on the so-called adequacy of representation by the Supreme Court in Devendra Singh versus State of Punjab. This adequate representation, whether it is education, admissions into educational institutions, or jobs in the under the state or the government, or in the legislatures, what is adequate is the biggest question that is really agitating in a person who is thinking about the representation of the scheduled caste through the fundamental rights in India. This adequate representation, is it equal to proportionate representation? Or is it equal to, what is it equal to? What is adequacy? Baba Saheb, while talking about this adequacy of representation, in some corners speaks, adequacy cannot be defined in numerical terms until the representation of all other communities are also decided. That is one aspect. And when it comes to equality of opportunity, under Article 16.4, Article 16.4 talks about equality of opportunity. This is a very critical analysis. Please apply your mind and be with me. Equality of opportunity is different from equality absolute. Absolute equality talks about proportionate representation. Proportionate representation means 1:1. But equality of opportunity, before discussing about equality of opportunity, I want to give my view about equality. Equality means it is basically a kind of a communism. Equality, whether necessary or not, equality whether eligible or not, equality whether capable or not, one should be given his share. That is absolute equality. Whereas equality of opportunity comes into picture when there are limited resources and more people, more claimants. There are only 10 opportunities and 100 people are claiming these opportunities. Then who should be given this opportunity? This is the biggest question when you have to decide on the equality of opportunity. The Constitution of India, Article 16, talks about equality of opportunity in matters of public employment. Equality of opportunity. Everybody should be given equal opportunity. Every graduate should be given equal opportunity to compete. Every graduate should be given an opportunity to test his ability on equal standards, on equal platforms, on equal terms and equal conditions. This is equality of opportunity. When 100 people are competing in a competition, and when there are 10 opportunities to be captured by 100 people, and all are given equal opportunity to compete, naturally, who will get the opportunity? The top priority is the person who is on the top. And when this is the biggest twist that you have, the difference between equality of opportunity and equality that you have to understand. The Constitution is talking about not proportionate representation, but equal representation. Constitution is talking about proportionate representation when it comes to political representation, whereas when it comes to representation in admissions in higher education or representation in the government jobs, particularly in the government jobs under Article 16.4, Constitution is talking about adequacy of representation. So what is adequacy of representation is the biggest question that is agitating. In the latest Supreme Court judgment, Supreme Court has given who will decide this adequacy or inadequacy. Supreme Court has given this right or this discretion to decide what is adequate or what is inadequate to the subjective satisfaction of individual state governments. This is the biggest difference that is the Supreme Court has brought in. There are 29 states, and 29 states can come out with 29 different standards for defining adequacy. This is the meaning of subjective satisfaction of the respective state to decide the adequacy of representation. Therefore, it is the biggest challenge before the Dalit community. Instead of getting played into the hands of the political necessities of individual regional parties or national parties in different states, it is the time for all of us to think and stabilize or standardize what is adequate, what is inadequate, what is proportionate, what is disproportionate, what is deficit, what is surplus, what is minority, what is majority. Unless these concepts are clearly mentioned, clarified, every state will come out with its own standard, and there will be huge litigation into the interpretation of these standards in high courts and supreme courts in the days to come. This is the biggest thing that is happening now. This is the adequate representation in the services, that is employment, and redress against prejudicial action or neglect of interest. That is, if there is any law, if the law is not implemented on equal footing, then the prejudices, if they are going into interpretation of law or implementation of law, they can also be challenged through the courts under the fundamental rights. This is another condition. The special departmental care. Ambedkar says this is a fundamental right. Special departmental care, that is a liaison officer or the National Commission for Scheduled Castes or the State Commission for Scheduled Castes in each state, is also a necessary condition for the scheduled caste to enjoy their equality under the fundamental rights or equality under the Constitution. Without these institutional framework, it would be difficult for them to get the justice. This was the thought process of Baba Sahib Ambedkar. This is another, the special classes on the cabinet. Baba Sahib Ambedkar went to the extent of asking for there should be a special provision in the constitution for giving births to the untouchables or the scheduled castes or the Dalits in each and every cabinet. But Baba Sahib did not ask only welfare ministry or the animal husbandry ministry. Baba Sahib Ambedkar representation in the cabinet. See, what I want to tell the audiences here is the fundamental rights, entire thread of fundamental rights from Article 12 to Article 35, whether it is their cultural rights, religious rights, constitutional remedies, educational rights, protection against exploitation, right to freedom, right to equality, all these rights, they have been discussed in the rudimentary form in the roundtable conferences as special safeguards for the scheduled castes in the future constitution. This is the work of, if there is any small fundamental rights that a Dalit is enjoying, along with all other citizens of India, it is the purest contribution, greatest contribution of Baba Sahib Dr. B.R. Ambedkar. I want to go a little into the history. How many constitutions Baba Sahib has taken help of to introduce the necessary conditions for the Dalits or the scheduled castes? Baba Sahib draws inspiration or the model draft from the 14th Amendment of American Constitution. American Constitution 14th Amendment took place somewhere in 1866. 1866, 14th Amendment came in Indian, the Constitution of USA. In that 14th Amendment, the civil rights for the Negroes, civil rights for the blacks were given through the 18th, the 14th Amendment. Before the 14th Amendment, there was a 13th Amendment to the US Constitution, which has abolished slavery. That abolition of slavery by the 13th Amendment in the US Constitution has become inspiration for Baba Sahib Ambedkar for the abolition of untouchability in Indian Constitution under Article 17, and the fundamental rights and the special protections in the fundamental rights have been taken as an inspiration of the model that comes from the Amendment 14 of the US Constitution. And the Government of Ireland Act 1920, there was a Government of Ireland Act 1920 in which the similar rights for the submerged 10%. There used to be something called untouchability or a little discriminated community. 10% of US in the Great Britain or the Ireland, those British under the within the British government, within the British Empire, not British Indian Empire. There used to be submerged 10. They used to face similar conditions as untouchables because of their professional backwardness or professional stigma. For removing those stigmas, there was an act called Amendment Act Act 1920, Government of India Act, Government of Ireland Act 1920. From that also Baba Sahib Ambedkar has taken this inspiration to implement, to incorporate some special rights for the Dalits or scheduled castes under the fundamental rights in the Indian Constitution. So this is a brief about the fundamental rights. What is happening with these fundamental rights, whether these fundamental rights are really being implemented, what are the bigger threats that we are facing to the very existence of very definition of these fundamental rights. I will give one example to you. In the recent census calculations, there is in Andhra Pradesh, especially in Telangana and Andhra Pradesh, there are two commissions appointed to study the conditions of scheduled castes for the purpose of subclassifying the scheduled castes into different categories. One commission was appointed in Telangana by name Dr. Shamim Akhtar Commission, and another commission was appointed. Was appointed in Andhra Pradesh, Rajiv Ranjan Mishra Commission. These commissions have studied the conditions of scheduled castes in terms of they claimed that they have studied the social, economic, political, educational, and all other aspects of the scheduled castes, and they are supposed to recommend whether the scheduled castes in Andhra Pradesh and Telangana are to be classified into different groups or not. I don't want to go into the total report or the total problem. I want to give two pieces of information of that commission and this commission as to whether the right to life under the Constitution, under Article 21 of the Constitution, fundamental right to live includes right to be enumerated in the population, right to be enumerated in the census. Whether it includes right to life or not, this should be the biggest question in the next coming national population calculation, national census. Why I'm telling this is, Dr. Shamim Akhtar report tells the population of scheduled castes in Telangana is 52 lakh today. Whereas in 2011, the population of scheduled castes was 54 lakh, some 50,000 plus. 54 lakh 50,000 in 2011 has become 52 lakh now. This is the scheduled caste population. To what extent this is correct? I want to give some more information. In 1981, there was a figure for scheduled caste and there was a figure for Telangana districts. And from 1981 to 2011, 91, 2001, 2011. There are three decades. In 3 decades, the population of Telangana has increased by 73%, whereas the population of scheduled castes has increased by only 63%. To what extent this population growth of population is correct is the bigger question. The population of the state of Telangana has increased by 73%, whereas the population of scheduled castes has increased only by 63%. This is the first anomaly in the enumeration, the enumeration process to be reconciled. Unfortunately, neither our representatives nor our officers have time to study all these aspects. That is one aspect. Number two is Shamim Akhtar says today the population of Telangana scheduled caste is 52 lakh. But there was another calculation of population, Sakala Kutumba survey. The family level survey was done in 2014 by TRS government when the state was bifurcated. In that population census, the scheduled caste population was 64 lakh. That means from 54 lakh odd in 2011, the population of scheduled caste has gone by 10 lakh in 4 years. Why it has gone by 10 lakh and the population of the entire state of Telangana has gone by only 18 lakh? Entire Telangana has gone by 18 lakh. In that, scheduled caste alone has gone by 10 lakh population. Is it possible? Can it be possible? Can that be accepted as a fact, or there is necessity for reconciling these facts? My point is, since 2011 population was done badly, enumeration was done wrongly, it was underreported, population of scheduled caste was underreported in 2011. This underreporting got corrected in this 2014 calculation by TRS government in the Sakala Kutumba survey. Why? From there onwards, today the population from 2011 to 2024, the population of India had grown at the rate of 17%. If you take this 17% growth rate of population, if you apply this growth rate to Telangana scheduled caste and taking the base as the Sakala Kutumba survey, which is 64 lakh, the population of scheduled caste in Telangana should be 73 lakh. This 73 lakh population is being shown by Dr. Shamim Akhtar, one-man commission, as 52 lakh. And he is coming out with a categorization of scheduled castes and their employment, whatever his purpose. My question here is Shamim Akhtar, when he was appointed as a one-man commission to study the conditions of the scheduled caste, he is supposed to take the population of scheduled caste, he is supposed to guess or estimate the population of scheduled caste as on today, because he is applying this population statistics to the adequacy of the representation is employment and political representation, whatever it is. I am giving this information for the simple reason. An official commission gives a population figure of 52 lakh, and based on this 52 lakh figure, the state government comes out with an act classifying the scheduled castes. That means they are freezing and normalizing and legalizing this population figure of 52 lakh and not at all bothered about talking about the 73 lakh population. That means a gap of almost 20 lakh population is being annihilated from the official records of Telangana. Similarly, in Andhra Pradesh, the population of 2011, the growth of population of after 2011 till 2024 gives the population of Andhra Pradesh scheduled caste as 99 lakh, and that one-man commission is taking the population figures of 2011 and calculating the population and the employment reconciliation, the ratio as 82 lakh. There also, they are reducing the population of 2011 by 2 lakh there. In Telangana, they are reducing the 2011 population by 2 lakh here. They are not bothered about taking about the population growth after 2011 and giving the employment statistics, education statistics, entitlements, all these things based on two different parameters. On the population is 2011, which itself is underreported, and the employment figures and education figures of 2024, and they want to decide the classification policy and decide adequacy and inadequacy of representation in higher education, higher employment, and political representation, and all these things. Why I am telling this is Dalits and the Constitution, fundamental rights. Whether right to life should also include right to be enumerated under the census reports. If the right to be enumerated is not a fundamental right, the figures given by the state governments will become facts, and 20 lakh population in Andhra Pradesh, another 20 lakh population in Telangana get annihilated from the official records officially. These are the bigger questions that the Dalit intellectuals, Dalit activists, Dalit representatives, political representatives, and Dalit official component should concentrate upon. These are the major questions. Unfortunately, our representation, political representation, I'm not going into the analysis of this representation, character of representation, nature of representation. But I want to conclude my speech in a few minutes by telling one thing. To take inspiration from Baba Sahib Ambedkar. Baba Sahib Ambedkar is a great reader by himself, is a philosopher. He was reading a philosopher called Montesquieu, who has written a book called Spirit of Laws. In that Spirit of Laws, book 2, Montesquieu tells the purpose of war is victory, and the purpose of victory is conquest, and the purpose of conquest is preservation. Baba Sahib Ambedkar, as a pragmatic philosopher, wanted to consolidate every piece of his victory into a law and preserve those pieces of law and pieces of victory in the form of a constitution. If we do not understand the nature of the fundamental rights, the essence of fundamental rights, and the necessity of fundamental rights, and the way they are being applied, the way they are being interpreted by the Supreme Court and High Courts, and the way they are being implemented by the state governments and the national government, if we are not vigilant to these aspects, these finer aspects and the higher aspects of the interpretation of fundamental rights, we are going to be the losers forever. We lost a victory in 1818, January 1st, in Bhima Koregaon. We won a war against the practice of untouchability against the Peshwas in Bhima Koregaon. But we did not have a visionary leader immediately after Bhima Koregaon to convert that victory into a conquest, and that conquest into a preservation of a document called Constitution to enjoy the victory of Bhima Koregaon. And Baba Sahib Ambedkar, as a wise politician, wise statesman, a pragmatic philosopher, he consolidated all the victory that he has amassed, all the conquest he has made, either educationally or in the form of fundamental rights or in the form of civil rights or in the form of constitutional rights. He wanted to preserve the special safeguards for the scheduled caste in the form of fundamental rights as well as constitutional rights in the form of this constitution. Unless we understand this constitution and try it in a consolidated way, political forces, social activist forces, intellectual forces in the form of professors in the universities or the research scholars or the social activists running various organizations. If all these forces come together, deliberate, discuss, debate, understand, and reformulate the nature and the essence of fundamental rights and reclaim our original rights. Our original right is, Ambedkar asked, the original right for representation was electing our own representatives by our own voters, that is, separate electorates. Unless we revive this demand of separate electorates, adequate representation does not come. Efficient representation, meaningful representation, effective representation will not come. We will have proportionate representation, which will be useless utterly as it is today. In politics, we have the proportionate representation, which is utterly useless. Baba Sahib Ambedkar's language is, it is a bogus representation. Ambedkar says it was a diabolical contrivance to cheat the Dalits in the name of representation without giving them any authority but only giving position is no representation. Therefore, these reservations in political reservations are totally to be changed unless we have a dialogue, a national framework, a national agenda for changing the representative character from the present reserved constituencies and reserved constituencies and joint electorates for the scheduled caste election to separate electorate by the scheduled caste, again with separate electorates and separate constituencies. We will not get this special representation. We will not get effective representation unless political representation is effective. We will not be able to give protection, protect all other safeguards that we are given under the constitution or any other special laws. This is my submission. I am sorry, I must have confused you a lot. I was not so organized to put across my ideas because I am speaking a little extempore. With this submission, I stop here. I would like my friends to ask any questions or enlighten me on these aspects, any further aspects on this. Thank you very much.
Thank you, Murthy Garu. Thank you. You gave a vast canvas. What was the situation, fundamental rights, what is the nowadays implementation, the background in detailed international experiences. I think it's a very eye-open and new light on the constitution, basically fundamental rights. Thank you very much for the opportunity to listen to you and hear to you to understand the constitution's framework. The basic constitution framework is definitely fundamental rights. I think you gave a detailed in terms of explain the different fundamental rights of nature of fundamental rights. Thank you, sir. Thank you very much. I think I request to participants to ask questions, and it will be it goes on whatever time. I think it could be finished in 20 minutes to the discussion. Thank you very much. Leave open to all. Siddhoj Rao garu here.
I would like to thank PSN Murthy Garu.
Sir, not only that, I am asking because of you how to moderate the thing.
I'm sorry.
I hand over to Siddhoj Rao garu to moderate the.
It's an excellent lecture, sir.
Discussion.
Especially at the end, as he has given the data, Telangana population data and Andhra data. It's really eye-opening. We have to work for that. And I'm really.
That is a different subject, but you have to moderate the whole fundamental rights of Indian Constitution. This is the national forum. That's why we have to be concentrated.
Anyway, thank you, sir. It's an excellent. And if I want to listen to someone who is able to raise some questions and some doubts.
Okay, thank you.
Hello, Namaskar, sir.
Namaskar, MR madam. What is this MR stand? What does MR stand for?
Sir, this is the name of the my institute, my son's institute, MR. He has taken the name of his father and he's taken the name of his grandfather because both of them are MR.
Great,
So,
great. Yes.
sir, I'm obliged today to hear a teacher's lecture. And you have enlightened us with a great knowledge, sir. Here, fundamental rights, most of the people do not know what are the fundamentals and what are the rights. You have very correctly defined it, sir, and enlightened our heart and enlightened our mind, sir. The main thing what you have said is Devinder Singh versus State of Punjab. In fact, this judgment has opened our eyes because the trend, sir, you have very rightly said, the trend which we are seeing in the high courts and the Supreme Courts and in the lower courts, people are saying there is no untouchability. And sir, what happens? The victim becomes the accused at last. Because how many times he has to say, no, this has happened to me, this has happened. They have a very cold thinking for the person.
Yeah, I want to intervene here. Baba Saheb Ambedkar in the roundtable conference itself said that this boycott and related punishments should be made cognizable offenses.
Yes.
A cognizable offense is one, if by occurrence of which the police officer can directly arrest the person first and start investigation without the permission of the magistrate.
Yes.
In a non-cognizable offense, which is not a serious, cognizable offense means it's very serious. It cannot be delayed. It cannot be delayed for FIR to be lodged first and then investigation started.
Yes, sir.
It cannot be delayed to verify the prima facie evidences first and then make the FIR and then make the arrest.
Yes, sir.
Cognizable offense is one where immediately the person can be arrested and immediately investigation also can be started without any delay. This is the meaning of cognizable offense. But unfortunately, the Supreme Court judgments or the High Court judgments these days are diluting this cognizable offense nature of untouchability, and they are asking FIR can be lodged in certain cases only after the prima facie evidence is established. This is how the untouchability, very nature of untouchability is being denied. Existence of untouchability is being denied by the courts.
Yes, sir.
This is a very sad turn of things that is taking place.
Yes, sir. The second very important thing you have said is, sir, what classifying the Supreme Court and the Telangana and Andhra Pradesh, sir. If they will dilute and they will vanish the population, what will happen, sir? Where we will go? Whether we can go to the High Court or whether we can do the Supreme Court, if the government itself is doing such things,
see,
they are eliminating the people, sir.
Ambedkar is the only answer for this. When the legislature deceives you, when the executive deceives you, when the bureaucracy deceives you, when the media deceives you, when the courts, when the Supreme Court, which is supposed to be the guardian of fundamental rights and the Constitution, also deceives you, Baba Sahib says, democracy survives only through vigilant citizens.
Yes, sir.
Citizens should be vigilant. That means we have to educate our community. These are the dangers that we are facing. This is the loss we are facing. This is the destruction we are facing. So that we have to enlighten our people. This should become a mass education process. There the role of educated people and the intellectuals come, and which is happening in a very, very minimal scale. Unfortunately, we should have
Yes,
taken
sir.
place in a very maximum scale.
But sir, how is it possible कि Kutum survey and government and this Mr. Shamim Akhtar survey, there is a big difference between 52 lakhs and 73 lakhs.
That's what I'm telling. See, from
Yes,
official
yes, sir.
record, they are annihilating the population.
Yes,
Baba Sahib wanted annihilation of caste, and
Caste
these people
and
are
this
inhibiting from official records the population of scheduled castes.
scheduled caste. Yes, sir. So ultimately, I do not know where we have to go and what the bell we have to ring, sir. Ultimately,
The bell was really, Ambedkar has really alerted us in 1927 itself.
yes,
Baba Sahib says in one of his articles,
yes, sir.
peace, non-violence as long as it is justice. And if justice cannot be taken through the route of non-violence, it
Yes,
is
sir.
violence which will take place. That's what Ambedkar said.
Yes, sir.
Peace with non-violence or
Yes,
justice with violence. What is required by the society?
yes,
The society has to be ready. Society has to be educated on these lines. We will take some course. That's where I am insisting on intellectual discourse. Some
yes, sir.
intellectual minds should come together and declare a national action plan for all these aspects. We are in a
Yes,
very
sir.
dangerous situation.
Yes, very good. So, sir, I've taken your time. Thank you very much. It was very enlightening lecture. And today I was feeling as we were in the class, sir. And for your information, I am also a law graduate, and I was a elected person also for the district council. And here I am for our people. Thank you very much, sir.
Great, man.
Thank you, sir.
Anybody else? Siddhuji?
Sir, anybody have a questions, please ask. Otherwise, we can conclude the whole wind up.
I'm not very conversant in using this YouTube unless I stand before a podium. Behind a podium, I will not get that force and the what is that? What is the sequence of thought process?
No problem, sir. No problem. I think, sir, it will goes to in YouTube. Then
Yeah.
we are inviting all the
What I suggest
scholars.
is
Please listen to me. This
what
goes to YouTube first. Then it has to be published as article. We are also requesting. Please send your article whatever possible time. Then third thing, it will be one gathering in 2026 to January 26 in Hyderabad. All
okay.
scholars, 75 scholars will be gathered in Hyderabad. That is the three things I want to tell you, sir.
Right,
Sir,
sir. Right.
nobody is there. We will conclude. Siddhojrao garu, please conclude.
I would like to thank each and everyone who have participated in this debate, and also I would like to specially thank Sri P.S. Moti garu for his excellent lecture, and thank you so much for CDS and especially Malepal Lakshmi garu for organizing this lecture, sir. Thank you so much.
Thank you, sir. Thank you.
Thank
Thank
you.
you.
Thank you, sir. Thank you. Jai Bhim. Jai Bhim. Thank you, Jai Bhim.